Now,
I'm sorry, please don't forget the
where
point
I was, yes, Chair.
you were about to make. In the context of hearing the testimony of a witness, and in fact, even beyond that, the applicable prescripts say that the rules of evidence that apply, for example, in courts of law, do not apply to commissions of inquiry. Commissions of inquiry may receive evidence of variety of forms which would ordinarily not be admissible in courts of law. But as I say, that's in the context, or that's provided for in the context of the commission receiving evidence towards the investigation that it was set up for. That's the context. Would you say that those rules with regard to the admissibility, acceptance of evidence would not apply to an interlocutory process like the one we have before us now? You would have that permissive manner of receiving evidence in the context of receiving evidence towards the investigation, but have a very restrictive process when it comes to interlocutory matters that relate to the Commission's investigative process. I'm asking that in the context of the point in limine that you are raising. Wouldn't there be an anomaly if that were to be the case?
Chair, in the normal route, that would be an issue to raise. However, in light of what you are saying to me, or what you are putting to me, I'll submit that in a quasi-judicial tribunal like of this nature, then I cannot take that point in limine any further if that is then the status quo. I will have to leave that point in limine and not argue it any further.
Thank you. I did not want us to reach a situation where, for example, we decide your point in limine along the lines of what I've raised with you without offering you an opportunity to respond. Well, I have offered you that opportunity and you have responded. You may go back to the point I asked you not to forget.
Oh, yes, Chair, thank you. Chair, I was making a submission with regards to the deletion or the alleged fraudulent deletion of conversations in the WhatsApp records. And I was further saying that Mr. Mogosti did respond to those allegations that were put forth by the evidence leader. And at paragraph 41, which will be at page 267 of the replying affidavit,
yes,
Mr. Mogosti says that he admits that he deleted the message dated the 11th of March that was sent at 11:29 a.m. And the intention was not to mislead the Commission, as at the time, he had not even contemplated bringing the application here in. He further says in the next paragraph, the sole intention behind the deletion was to protect my conversation with the first respondent from third persons. The next paragraph, he says that he admits that he deleted the calls on the basis that at the time of taking the screenshots for purposes of this application, he did not find them relevant, and furthermore, he's further to allow me to take screenshots of the relevant facts. I therefore deleted them. I understand this, Chair, and I'm subject to correction to say that to allow me to take screenshots of the relevant facts, his headset doesn't allow him to take screenshots. I'm uncertain how to read this, and I seek the guidance of the Commission.
No, just make your submissions.
I submit that.
There's no need for guidance from us on this.
I submit that, and subject to correction, that his handset did not allow him to take screenshots of the relevant facts. He therefore deleted them. The calls that have been deleted were unanswered and therefore hold no significance to the application.
Except, of course, that they may assist in the context of what I engaged you on right at the beginning. I will not repeat that. Please continue.
Chair,
the point I made about, based on the number of calls, who appears to have sought out whom in that context. Please continue.
Chair, what is common cause is that, yes, there was communication between Mr. Mogosti and the evidence leader. And during those conversations, a discussion came in regarding Mr. Karim. It's also common cause that during the conversation, there was an agreement or a request to bring certain evidence to rebut what was put on record regarding Mr. Mogosti, to defend himself, and if the need arises, to throw Mr. Karim under the bus. Now, Mr. Mogosti's evidence is that the communication between himself and Mr. Karim formed an impression that his cooperation in providing information against another witness was linked to his treatment in the proceedings. And this, Chair, will find at paragraph 7 of the replying affidavit. And he further says that whether intended or not, such perception undermines the appearance of impartiality. Now, it goes back, Chair, to whether or not a reasonable, objective, and informed person would apprehend bias. Now, with what had transpired and with Mr. Mogosti due to come back to the Commission and testify, and him not being able to have provided any information that was helpful because the meetings never happened, he became fearful of appearances of impartiality, and that he would, upon his appearance, be treated unfairly.
Mamani, is it not opportunistic to offer Mr. Chaskalson information on Mr. Karim? and then fail to deliver because Mr. Mogosti turns out doesn't have that kind of information, and then say, I fear that Mr. Chaskalson will be biased against me because I did not give him that which I promised. Isn't there some opportunism there? You offer, and then you fail to deliver, and then without more, you say, he's going to be biased against me. I mean, he hasn't referred us to anything in the chats which shows Mr. Chaskalson being upset with him or saying to him, you know, I'm going to get you for failing to deliver. There's none of that, other than that text which we have read in context, that it actually doesn't quite convey what you were saying, where it says, don't mess with me, don't mess me around or something like that. I don't understand how that an offer made which couldn't be fulfilled without more creates a reasonable, remember the test is reasonable apprehension of bias, how that would create a reasonable apprehension of bias that after this he's not going to treat me fairly.
In response, Commissioner, what we had considered is that Mr. Mogosti is the one who called the evidence leader. That is not in dispute. However, what was contained in the phone calls, and I had said previously, I do not know, and neither does anybody know what was discussed in these telephone calls.
Then in that case, how can the commission say the apprehension is reasonable if we don't know what was discussed in those calls? You're saying that we don't know, therefore we don't have the content of those telephone calls according to you. So we lack the necessary facts on the basis of which the commission can make the determination that the apprehension is reasonable, because eventually that's what we must find. We must find that the apprehension is reasonable.
Commissioner, firstly, I'll invite the commission to make a finding through what is contained in the papers. Now, what seems to be a challenge is that with regards to the telephone calls, there's a dispute of fact. One says, I said, the other says, I said. Hence, I keep on repeating that I do not know what was contained in the telephone conversation. And Commissioner, you would also not be in a position to know what was discussed in those telephone conversations. And unfortunately for me, there is no recorded conversation of what would have happened. I will rely on the submissions that my client makes before the commission. Now, I had said previously that he's labeled as a liar. He was labeled as a liar. Now, if he approaches you, this liar, and he says, I've got information, why would you be interested in information? He might be lying to you.
I wasn't taking you back to that conversation. I was really addressing your submission where you say, we don't know what was discussed. You don't know, the commissioners don't know what was discussed in those telephone calls. That comes from you, it's your submission. So I was asking the simple question that if we don't have the facts about those calls, what was discussed, are we in a position, at least as it relates to those calls, is the commission in a position to make a determination that what was discussed in the calls creates a reasonable apprehension of bias. That's all I was putting to you. And maybe to reframe it, maybe can I ask you this? Do you accept that for a